Thank you so much, Attorneys General Marshall, Wilkin, and Nandlal, and of course, Ms. Roberta Clark, Commissioner of the Inter-American Commission on Human Rights. We are off to a robust start for sure where the presentations are concerned. And while the photo op is being taken, remember that the Hoover app is still open. I know Darren gave you a very simple, easy, and comprehensive instruction in how to use it. Please feel free to use it. Some questions, clearly, because of time, we're going to have to address at a later stage in the day, but we'll try to make that facilitation available to you as well. And you know what? Never underestimate going up to any interested party to seek further information and increasing your networking opportunities. So don't forget, continue to use the Hoover app to submit your Q&A through the recommended tool. Up next, this session is going to explore how justice systems can adopt survivor-centered case management models that enhance access to protection orders, reduce delays, and ensure coordination. This discussion will highlight challenges, lessons, and innovations from Barbados, Jamaica, and the United States. To open this session, we will first hear a presentation by Ms. Anika Gray, Gender Specialist at the Caribbean Development Bank on Integrated Service Delivery, Lessons from Latin America and the Caribbean. Please give a warm welcome to Ms. Anika Gray.
Good morning, everyone. Good morning, everyone. No, something better. You've all been fed. Good morning, everyone. It's afternoon. Okay. All right. You get a pass then. So good afternoon, everyone. Now, I don't know about everybody else. I'm Jamaican, so my family is in Jamaica, so I'm here, but I'm also mentally in Jamaica at the same time. But this morning, I woke up feeling very good. Despite everything that's happening, I had a lovely breakfast. The sun is shining beautifully, and I'm in the land of cheese on bread, Barbados. So I'm feeling good this morning. So to start off the session, I am going to invite all of you to join me in a little icebreaker session. It's nothing complex. It will not require anything hard of you. It's a little call and response, something that we in the Caribbean know very well, right? So are you willing to participate? You ready? All right. So when I say, I'm feeling, I want you to say, good, good, good. Yeah, you get it? When I say, I'm feeling, I want you to say, good, good, good. So let's do a trial run. I am going to say, I'm feeling, I'm feeling, I'm feeling. All right, that's the first part. The second part now, I am going to say, I am feeling good, and you're going to say, good, wonderful, good. And you're going to sing it. And remember, when you're singing, ladies and gentlemen, you need to sing not from your throat, but from your diaphragm, okay? So, I'm feeling. Remember, guys, it's good, wonderful, good. All right. So, I'm feeling. I'm feeling. I'm feeling. Great. Thank you guys so much. Clap yourselves for being a wonderful audience. So thank you guys so much for, especially to the organizers, for inviting me to be here for this very important conversation. And so I'm going to be doing the session a little bit differently than what was envisioned or what was spoken about a while ago. This particular session is focused on exploring innovative solutions to creating or designing a survivor-centered case management system for domestic violence cases. And I am, as the PowerPoint says, I am Anika Gray. I'll be your moderator. But joining me for the conversation are three brilliant and trailblazing members of the judiciary from the US and the English-speaking Caribbean. And first up, and I'm going when I call each person, please come to the stage, please. So the first person that I'm going to call on stage is the Honorable Magistrate Douglas Frederick from the Barbados Judiciary. Please, you can clap him, please. The next person I'm going to call on stage is the Honorable Tandra L. Dawson, and she's a judge with the Integrated Domestic Violence Court in the New York State Courts. Please. And joining us online, and she will come on online in a little bit. You will see her online in a little bit once we start the discussion. But joining us online and waiting patiently for our friend, Melissa, is the Honorable Judge Sahai Maxwell-Whittingham, who is with the Jamaica Judiciary. So please, round of applause for our panelists. Now, to provide the context for this particular discussion, I'm going to be giving you all a brief overview of three things. First, I'm going to be briefly touching on the issues related to case management processes for domestic violence cases. I'm also going to be focusing on the criteria. What would a survivor-centered domestic case management process for domestic violence look like? And finally, I'll be highlighting very briefly three judicial or innovative justice sector approaches that the panelists will be speaking on in depth. But if these particular approaches are implemented in the correct way, if they're implemented properly, then they should satisfy the criteria that I'm going to be outlining in the presentation. So Carol, in her presentation, would have briefly outlined some of these issues, but I'll just go through them very quickly. So the first issue is the issue of delay. And delay not only in relation to the hearing of the domestic violence applications, but also delays in relation to the hearing of other cases that are connected to the domestic violence incident, including custody matters, maintenance matters, and also matrimonial proceedings. So that's one. The second issue that the case management processes would normally encounter would be the issue of the lack of enforcement. And the Attorney General from Guyana would have spoken a little bit about the lack of enforcement as it relates to breaches of the protection orders in particular. And those breaches of the protection order and the lack of enforcement in many cases fosters an environment of impunity. And that impunity, of course, leads to or facilitates a situation where there is a lack of offender accountability. The other issue, and this again is something that Carol would have mentioned in her presentation, is the lack of effective coordination amongst the different justice sector actors who are charged with dealing with these cases. And by justice sector actors, I mean the police, the prosecutors, the magistrates, the service providers such as the social workers or victim support units, etc. And that disjointed nature of the service provision in many ways can impact how the survivor interacts with the system and how the survivor feels about interacting with the system. And the third issue that case management processes would normally encounter is the issue that comes from the previous three. So the delays, the disjointed service, as well as the lack of enforcement lead to a situation where survivors do not find that the system is very friendly. They do not find that the system is very responsive to their needs. And in many cases, that lack of responsiveness and that unfriendliness is due to either the justice sector actors are operating from a situation of bias, and again, Carol mentioned that in her presentation this morning, or they're simply overworked. And so being in that particular situation, they cannot effectively respond to the unique situation of a survivor who, in many cases, is very much connected emotionally, psychologically, and financially to the person who has committed the harm. And so that close connection can make dealing with these type of cases very complicated, and many of our justice sector actors do not have the training and the capacity to, how should I put it, to be able to understand and deal with those complexities. So those are the issues. So what would a survivor-centered case management system look like? It would have it would need to satisfy 4 criteria. So first, there is the issue of timeliness. We cannot have delays. There has to be a situation where there is timeliness in the hearing of the applications. There's timeliness in the hearing, not just of the domestic violence application, but timeliness in the hearing of custody, maintenance, matrimonial proceedings as well. The second criteria that it must satisfy is the criteria of being gender responsive. And being gender responsive not only to the needs of the survivor, but very importantly, if we are very serious about prevention, it needs to be responsive to the needs of the party that has committed the harm. The third criteria is that the system must be coordinated. And we do have some form of coordination in most of the islands in relation to the different service providers. However, the coordination is not as effective as it needs to be. So you need to have an institutional mechanisms put in place to ensure not just coordination, but effective coordination. And finally, the system has to have accountability. And accountability not only for the person that has committed the harm, but also accountability for the justice sector actors themselves, who have responsibility for providing the particular services. And as an example of accountability, the cases of OOO against BK, as well as the Tot Lamkin case from Trinidad, are examples of ways the courts have held some of those actors responsible. However, that is only one form of accountability. Oh, sorry. Now, for this morning, we will be looking at these three innovative justice sector approaches, namely protection orders, integrated data systems, and specialized domestic violence courts. And all three, if they are implemented properly, and I'll put an emphasis on that, if they are implemented properly, should satisfy most, if not all, of the criteria that I would have outlined above. So take, for example, the protection order. The protection order does a number of things, and I've highlighted 3 of them that are very important. So first of all, the protection order, if it is done correctly, empowers the survivor to actually leave the abusive relationship, because the magistrate has the power to grant custody orders, maintenance orders. They also have the power to grant orders in relation to occupation of the matrimonial home, or tenancy orders, something that the Attorney General from Guyana spoke to about this morning. Most of the legislations in the different countries also allows the magistrates to make restitution orders. And so all of those things are very important in empowering the survivor to be able to move away from the abusive relationship. The second thing that those protection orders are able to do, if they are done correctly, is that they provide time-bound safety or protection for the survivor, because in many cases the survivor will need time in order to rebuild their lives without the constant fear of being subjected to violence. The third thing that the protection orders provide is that they allow us to prevent future harm. And it does so in 2 ways. So even though the initial protection order is limited in terms of time, it is time-bound, it can be extended. It can be extended if the circumstances that led to the granting of the initial protection order persists. So that's one way that it can prevent future harm. The second way in which it can prevent future harm is in relation to the orders that the magistrate can make as it relates to the person who committed the harm. So for example, under some legislation, the magistrate is empowered to mandate that the individual who committed the harm goes to mandatory counseling, or in many situations, the magistrate is in many cases empowered to order the person that has committed the harm to go into some form of offender rehabilitation program. So that's the protection order. The second innovative solution that we're going to be discussing, and again, I'm just providing a framework. There will be more discussions with the panelists. The second one is an integrated data system. An integrated data system, and again, there has been conversation in the previous panels about the importance of data. But an integrated data system allows the court or allows the system to track and measure the performance of the actors within the system. It also allows, in tracking the performance of the actors within the system, it also ensures or can allow for timely case disposal. So remember, we said one of the criteria for a survivor-centered case management system is that it must be timely. Data can help you to do that. The other thing about having an integrated data system for domestic violence cases is that it provides a centralized place where the different actors can access specific information. And this particular point is very important if you have an integrated system. Because if you have an integrated system and you are coordinating there's coordination among the different actors, then all of them would need, in many cases, access to specific information. And an integrated data system will allow that. And finally, in relation to the data system, when you have the first 2, you eventually will have the last one, which is that it creates a more survivor-friendly process. And finally, we will be looking at domestic violence courts, which generally would integrate the first 2 that I just mentioned. It would integrate protection orders, and it would in many cases it would also include an integrated data system. But some other important features of a specialized domestic violence courts court would be, one, there is comprehensive intervention or support for survivors. There's also coordinated response from the service providers. There is staff with specialized training, which is extremely important because remember we said the system has to be gender responsive. For you to be gender responsive, you need to know what the needs and concerns are. And there has to be support. And again, this is something that I am very, very much adamant on, that there needs to be support for the parties that have caused the harm. And finally, there has to be timely disposal of cases. So that's my presentation, and that's the most that you'll hear of me for the rest of the session. You will now get a chance to hear from our amazing panelists, and we'll be discussing these three things that I just highlighted. Mic check? Great. I just want to confirm that Judge Maxwell-Whittingham is online. Is it possible for her to be on screen? Okay.
Good morning. We come online. Morning, Anika. That was very good. A very good presentation. Thank you.
Oh, was that Judge? Sorry. Judge Maxwell-Whittingham, I can't see you.
Sahai's fine. Sahai's fine. You know me. Sahai's fine.
Okay, great. Yeah. Woo! It's so good to see you.
Thank you. And it's good to hear you. And I saw you earlier. I'm not seeing you now, but it's good to hear you. Good to hear you and see you.
Yeah, man, definitely good to see you. And of course, we have you, the entire Jamaica, your family in our prayers, and my family as well, yeah?
Yes, I know. Thank you.
Yes,
Thank you
yeah.
very much. I got the note. We are
Yes.
here just hoping for the best.
Yes.
And so far, it's not as bad as it has been anticipated. So we're hoping it stays this way.
We're hoping it goes west, west, west. Yes.
Yes, yes.
Exactly. All right. So to start off our conversation, I will start with you, Justice Magistrate Hendricks. And in 2023, the CCJ in OO against BK et al. Held that former intimate partners in cohabitational as well as visiting relationships would be entitled to seek protection order under the definition of former spouse in the Barbados Domestic Violence Amendment Act of 2016. In so doing, the CCJ rejected the position of both the magistrate and the Court of Appeal, who would not or could not comprehend how a former spouse could be included as a former intimate partner from a cohabitational as well as visiting relationship, even though the applicant and the respondent shared a child. In coming to its decision, the CCJ noted that the role of protection orders in providing protection and safety to survivors of family violence. It also noted how the Court of Appeal's decision led to many survivors being turned away because they supposedly did not fall into the category of former spouse. And it also noted that the injustice that can be caused by inflexible or rigid application of law devoid of any understanding of the social context. Now, in light of the CCJ's decision, how have protection orders in Barbados evolved as a tool for survivor safety, and what barriers still exist for survivors seeking these protections?
Right. Thank you very much for that question. And I totally agree with the CCJ on that, because when one examines the factual matrix of that case, you would see that it was a logical decision by the CCJ I never knew, I never understood how it got that far. That's the truth. But that gap has been closed in the 2016, the 2016 amendments for sure, because the 2016 amendments has placed that quite beyond doubt. It has enlarged the categories of persons who can apply. In fact, they have gone so far as to say that once there's a connection by consanguinity or affinity, then that person is entitled to apply. And it has repeated itself. I think the 2016 amendments have purposely repeated itself in terms of saying spouse, former spouse, and then it goes on with that mopping up clause, that all-embracing clause of consanguinity and affinity. It's unfortunate that persons interpreted without hearing the evidence or allowing the person to give the evidence, because the real purpose of this protection order is to allow a person to come and make an application. Laypersons come and make applications. They fill out the form. The rules of evidence are relaxed. That's the purpose and intent of the act. The rules of evidence are relaxed, and is really for the person to get before a magistrate and have an audience with a magistrate who is supposedly trained and be able to dissect and understand these things. If the person don't get an audience before the court, then how can they really express themselves in layman terms that will gel for the magistrate to understand? So you really have to knock out those objections that lawyers might come with, that persons may come with, that even the clerks at the court, when people come to fill out applications, I beseech clerks, do not turn away anyone. This is a legal matter. You are dealing with the administration. Let me deal with the legal person, legal matters. So let them come before the court. I will hear the application, hear the extent of the application. And if need be, sometimes we refer them for their own safety to a unit which we have that has been doing some very tremendous work, the Family Services Unit of the Police Force, the conflict resolution, conflict unit. And I think Miss Christine Husbands, who is here with us, she can attest to this, and her team, they have been doing tremendous work. So out of those things, some support services have worked with us to close those gaps. And I'm sorry that had reached that far, because it ought not to have reached that far.
But lawyers, yes.
Yes, yes, yeah. And there's another thing too, right, that I've heard discussed today, and that is training for judicial officers. As you know, we don't have a specialized court for domestic violence matters in Barbados. What we have is courts in every jurisdictions, and therefore the level of understanding might be different, and it varies obviously from court to court. You know, with time and experience and training and exposure to seminars such as these, you get the experience. But sometimes you have a magistrate who is acting, and a matter that is extremely serious might come before the magistrate, and that magistrate has to make a determination on that. And therefore, you can get these matters that are determined like that, unfortunately.
So outside of the barrier that you just mentioned, are there other barriers, existing barriers in relation to protection orders?
Yeah, there are some existing barriers. You see, we can sit here in these forums with persons who understand these things, but the persons who are really vulnerable are the persons at the grassroots level, and therefore you need that education out there at the grassroots level in language that they understand, because many times people come before the court and they don't even recognize, as Attorney General for Guyana said, that this particular treatment that they've been getting is domestic violence. And sometimes these vulnerable persons have persons who are close to them who might not even know, and they seek advice from them. So therefore, there's a need for a public education campaign at the grassroots level to really let the people, because how are you going to know that you have rights if you don't know what your rights are? So that is important. There's a need for that type of campaign. That's a barrier. There's another one. because it's a small society as well, persons fear that their matters may get into the public domain. There are people who feel that, what are going to become of my children and such like if I go and the breadwinner of the house is taken away or something like that, an order is made. But there are resources now. There are things that we put in place. As Attorney General from Guyana said, we have similar provisions in our legislation where a person can be asked to leave the house but still pay the rent. A person might be asked, we may even compartmentalize the house in some instances where it has that facility, say, well, don't enter into the private space of this other person and stuff like that. And those things have been working. But we need to have that grassroots education program.
Okay, so just as a follow-up in relation to the existing barriers, we know that under the DVA in Barbados, a survivor can apply for an ex parte order if they can show urgency of their situation. And this, of course, is intended to provide quick relief for the applicants. But one persistent complaint, Magistrate Hendricks, of those who successfully obtain an ex parte order or just a standard protection order is the slow response of the system when it comes to enforcing the criminal sanctions when the respondent violates the terms of the protection orders, including orders related to non-molestation. So from the perspective as a magistrate, because you're in the line of fire, because most of these cases would come before the magistrates, what innovation or judicial practices have proven most effective in ensuring timely issuance and enforcement of protection orders?
Right. Well, once an applicant comes before the court, it is mandated that that matter should be heard within 7 days of the matter having been filed before the court. So it is time bound. But then when an order is made, then particular magistrates, and I do this, I ask for a review. I ask the persons to come back for a review. I send them to counseling as well because it's mandated in our act that we have to send them for counseling. And we send them for counseling at the Family Services Unit. Sometimes we have to put the persons into protective arrangements with the Family Conflict Unit. They will take care of that for us. And we call for review, and we get reports from the counselor as to how the person is adjusted and such like. But in circumstances where the person still occupies the same house, if there's a breach, then that person, the victim, makes an application for a breach of a protection order, and we hear that almost immediately, right? The police also have a very serious role to play because you said I'm at the forefront, but I come in at the back end, really, to my mind, because the police officers are the ones who are invariably called to respond to those matters. And in the 2016 amendment, they have the power to issue emergency protection orders. And also we have the power to apply something called a warrant of arrest. And if that person is alleged to have or has demonstrated that they are in breach of the order or continues after being warned in breaching the order, the police officer has the right to arrest that person without warrant and bring them as soon as practically possible before the courts. So that is our mechanism for enforcement. There are some gaps, of course, because as you know, and everybody in here knows, that a protection order is a paper, really. And in the dead of the night, when the two parties are there, the police is not there. And therefore, there's that gap. There's that opportunity for a perpetrator who is bent on breaching the order to do some dastardly act. But what we have been able to do is to get the social services involved as well, to try to quell that. And there's a mechanism that I use that I find that is effective. You have to give the parties time to talk in the court and understand where they're coming from and to be able to analyze their state of mind. It is something that you get from experience. You have to understand, because a person, a perpetrator, might go quiet, and you might believe that because he's gone quiet that he's willing to comply. But you have to be able to read that, and that comes from experience and training. So it's important that you give them the opportunity to voice and also that you read the signs.
Okay.
Yes.
Okay, thank you, Magistrate Fredericks. Now, Judge Dawson, I'm going to turn to you because unlike Barbados and other Caribbean countries, the state of New York does have a specialized domestic violence court, and you have been presiding over that particular court for nearly 2 decades. So that's a long time.
It's a really long time.
Yes, and the court uses the one family, one judge model. Could you walk us through quickly how this model operates and the legal framework that supports it?
Absolutely. And first, I want to thank the organizers for inviting me to present before this very distinguished audience. I'm very pleased and honored to be here today. So first off, let me begin by giving you a brief history about why and how this court came about. And specifically, I preside in the integrated domestic violence part, which is located in Manhattan in New York City. Hopefully, most of you have been there. If not, I welcome you to come. And if you're in town, visit my court anytime. But the necessity of this court arose out of the challenges that survivors of domestic violence faced when they finally decided to leave their abusers. Most of us in this room who have worked in this field are familiar with that process. It took a long time. Sometimes a survivor just suffered in silence and stayed with their abuser because of the children, maybe because of financial reasons. There were many, many reasons that are very deep and very sad that they decided to remain with their abuser. So eventually, when the survivor decided to come out of the situation, to report her abuse, and to come forward and go to the justice system, we found that they faced a new quagmire, the quagmire being the court system. And advocates who represented these survivors came forth with a unified cry to the then chief judge. She passed away, but Judith Kay, who was really a trailblazer in this arena. So back in 2001, Judge Kay decided that change had to be made to streamline the process for survivors, to make it easier for them to navigate the court process, and to have a concentrated court which had dealt with the survivors' criminal cases, the family court cases, and also the matrimonial cases. So as I was saying, the advocates for this, for the group of people, the survivors of DV, were really fed up. And with their collective advocacy to Judith Kay and the powers that were at that moment in time, they came forth and she determined that this was necessary. There were some roadblocks because initially she wanted to have legislative change and have the legislature create a law that created the authority for this court. Well, that didn't happen, surprise. So she created a court rule that was basically codified under Part 41 of the Chief Judge's Rules and Regulations. And I did provide a copy of that in the materials that were provided to you. But that rule codified the Integrated Domestic Violence Court and gave us the authority to create and implement the court. With respect to how we operate, our court first employs the following criteria. The parties who come before us have to be intimate partners, and intimate partners has a definition under the law in the Family Court Act. They are parties who are married, formally married, dating, parties who have children in common, and they can be same-sex partners, Heterosexual partners, there's no differentiation of that in the New York law. To qualify for our court, there must be a criminal case. So in other words, someone has been arrested and there's a corresponding family or matrimonial case. So what we do is identify these potential cases by looking at a computer database of criminal and family court and matrimonial civil orders of protections and criminal orders of protections. And what we do is the clerks will look at this computer database and identify families that have both matters pending in both jurisdictions, criminal and civil, and pull those cases for me and my staff to review. My staff and I discuss the merits of those cases and determine which ones are appropriate for IDV. We transfer those matters to my court, and my court is situated in the Supreme Court of New York, which is a trial level court, but it is considered the Supreme Court in New York State. And we schedule those cases for what I term time certain intervals. So for example, I may schedule a case for 10 a.m. We would call the criminal case first. I would hear that case and adjourn it. Then I would call the civil case, which would be the matrimonial and or family case, hear that case and adjourn it to the same date and time. Even though the cases are being heard at the same time, they're still separate and distinct. They have the same rules as though they were in their courts of origin. So there's no mixing of the cases. They're still separate. They have their own procedures and confidentiality rules, standard of proofs. All of that remains the same as though they were in their courts of origin. We also have the benefit in IDV of having cross-trained attorneys, and these are lawyers who are trained to represent the parties on their criminal case and their civil case. And this is something that we did when we first implemented the IDV part, because we recognized that having one lawyer who could represent the parties on both matters was more valuable, and it sort of fit into the whole protocol of having the lawyers who were more informed about their clients' issues. They were privy to confidential information that might be in both dockets. So it was a better system, and also worked together for us with respect to keeping the cases together and keeping them on the same day. Criminal defense organizations cross-trained some of their lawyers to represent their clients in IDV. And even we had prosecutors who were specially trained with respect to some of their units to appear in IDV. Going back to why we call the cases at the same time, one of the hallmarks of IDV, as I said, was to streamline the process, make it easier for survivors to navigate the system. So we decided if we call the cases at the same time, this lessened the burden of litigants to have to take time off from work for multiple appearances on their various cases, which was an issue for some survivors when they finally decided to navigate the system and report their issues. We have more information that's available. For example, a prosecutor might be sitting in the audience and hear information on the civil case that they could use in their prosecution of the defendant. So it was a great process in order to have a more informed attorney base, as well as for the litigants to understand what was going on, and also to make sure that the process of coming into court was easier for them to navigate. Our court also boasts a resource coordinator, which is novel for a court. And the resource coordinator is a link between our court and the resources that we have available to us in the community. And this person finds programs which help facilitate dispositions, progression of cases and resolutions. They find programs such as abusive partner intervention programs that we utilize, supervised visitation agencies, Administration for Children's Services, and other agencies. So I get those reports when I need them, when I've sentenced people to attend a program, or when parties are involved in programs as the case progresses along. Should I continue?
No,
I've
but
been
I
describing-
have a, I have a quick, two
Okay.
quick follow-up questions
Sure.
for you. So the first is, are there court-connected programs in relation to providing support for the party that has caused the harm in the relationship? So that's one. And the second, you mentioned that only domestic violence cases where there are other matters such as a custody or matrimonial proceedings go to the IDVC. So what happens in situations where there's a domestic violence incident and none of those cases apply?
So the linchpin to qualify to come into this court is that there must be a criminal domestic violence case. So I only handle domestic violence cases between intimate partners. And the reason for this is, and many IDVs across New York State have different types of criteria because of the resources that are available and the issues that the community faces. So in Manhattan, what we did before we even implemented the court, we kind of looked at the caseload and the cases that were pending to see what made sense in terms of volume, in terms of importance, in terms of where our resources would do the most good. So we narrowed this huge area of domestic violence down to intimate partners. And our court tries to concentrate on intimate partners, former intimate partners, married people, et cetera, who have children. And, but we also have a lot of cases where the parties do not have children. But so in order to get into our court, there must be just the domestic violence connection with the intimate partners, either in the criminal side or family or matrimonial cases. So this is why we look at the registry to see which cases have orders of protection. So the clerk may see a matrimonial case that has an order of protection issued, or a family court case. So once we identify that there's been a criminal arrest and we make the connection with the civil matters, then we review that and pull those cases into IDV. And our volume is huge with just that limited criteria.
And my second question in relation to court-connected programs for offenders.
Yes, and I'm glad you raised that because it's very important. Because we do concentrate on survivors and making sure survivors and their children are safe, and that we have swift justice and there's offender accountability, it's also important to be responsive to the defendants and respondents, because otherwise, and this gets into a larger issue of challenges, I know you're going to ask me about that later on, to have the buy-in of all of the various stakeholders. And as a judge, I can't sit in my role and only handle survivors and people who are saying, I'm afraid, there's been abuse. I also have to be responsive and balanced in responding to defendants and respondents. So our resource coordinator also calls programs that specifically are related to defendants and respondents. And some of those programs include fatherhood programs, or programs that help them get jobs, because we know people who are unemployed, are more likely to be upset and commit domestic violence. And also wraparound services for these respondents and defendants. And a lot of the defense bar, they're very happy with these programs. And some of them will even continue with the programs after the judicial oversight and mandate has concluded. So I'm glad you asked that, because it's very important, and as a judge, it's important to be balanced, because a lot of times, a lot of these parties do have children, and even though I've had supervised visitation in place where there's a social worker present observing the interaction between the parent and the child, maybe eventually this case will lead to unsupervised visitation, where not only will the defendant have to have connections with the child, but also with the survivor, because they have to co-parent in some type of way. So we need to also make sure that the respondents and the defendants are receiving services that not only penalize them or punish them, but also build them up and give them the tools to navigate and understand why they did what they did, and hopefully stop that behavior from occurring in the future.
Absolutely. And just to say that taking care of the needs of the party that has caused the harm is also a way of taking care of the survivor.
Correct.
Yes.
And I'm sorry, just one other thing.
Yes.
A lot of survivors still need financial support from these from the perpetrators. So there's a whole huge holistic approach to IDV that is so important and key. And when you have a plethora of services and you have a resource coordinator whose sole job is to look around the community and try to figure out what can we put in place so this family can operate outside of court and somehow get to a point where domestic violence is not their modus operandi. That's one of the areas that we try to concentrate on, which is, I think, one of the reasons why the court really operates well.
Absolutely. Thank you so much, Judge Dawson. And so now we're going to move to Jamaica. And Judge Maxwell-Whittingham, it seems that one of the big focuses for the Jamaican judiciary is the use of data and digital tools to increase efficiency, especially in relation to increasing case disposal rates in an attempt to reduce backlogs in the system. So my question is, how therefore is Jamaica's family court system, which is responsible for handling the domestic violence cases, integrating digital tools and data to improve case tracking and timely disposal of matters? Can't hear you. You're
Hearing me
yes.
now? Hearing me?
Yes.
Okay, all right. Thank you for that question. And I'm enjoying the panelists so far. I'm learning, just Judge Dawson. I am very intrigued by your court, and I'm feeling inspired to push for something similar for Jamaica. As you raised, Anika, yes, Jamaica, our justice system relies a lot on data. What I will do, I'll speak to my own personal experience, and I will go a little bit further and speak to the experience of my husband, who also sits as a judge, and he is also a family court judge. Now, with the need to push for data as our system is so focused on, naturally, it is going to require some amount of consideration by the judge as to the amount of time spent on any one case. Now, I've always been a proponent of justice, not rush. And I believe so, especially as it relates to family court matters, in particular domestic violence matters. Now, if it is that justice is not to be rushed, and Jamaica is focused on data, and data is directly connected to time-sensitive considerations of the cases. What does that mean for the family court matters? When I started as a family court judge in 2017, I remember it was a different Chief Justice back then, Justice McCullough, and the energy surrounding the family court back then was a little bit different. The focus on justice was a little bit different too, because while data has always been something relevant, it was not as relied on in the way that it is relied on. And so for us judges sitting in the family court, we, and I speak for myself and my husband because we discuss it when we come home, we believe that we need to hear the parties. And I don't mean just look at what they place on the affidavit. Yes, for an ex parte application, you can rely on the affidavit and get an idea. But certainly where both parties, for example, are before the court, it is important for me as a judicial officer to hear all the parties, to listen them out, And I remember when I just started in the family court, the clerks and those who were there long before I came there, they would be annoyed with me because they would say, Judge, you listen too much. You make them talk too much. And I just didn't understand it. I didn't understand it because for me, I believe you should treat people as you want to be treated first. Whether I'm a judge or not, as a human being, basic human concept. Treat people as you want to be treated. Now, if I, as a layperson, go to a court, especially a family court, and I'm addressing the issues, I want to be able to speak about everything that I believe affects me in the way that I'm before the court. I can understand that not every single detail is going to be allowed to be said, but certainly we can't cut and paste justice in the context of the family court. And when I say we can't cut and paste justice, it is for that very reason. I've always indicated here in Jamaica that we can't treat the family courts as we treat the regular courts because it's different. It's different. And so when you can expect to focus on cutting down backlog in the regular criminal court and the regular civil court, backlog is not something that it should be and can be the focus in the family court in the way that it is in the regular court. Because family court matters, as we all know, are different. As we know, sometimes the matters come before us as a domestic violence application. And when you open up the application, you see that the application stems from an issue of custody or an issue of maintenance. So what you have to do, you have to fix those issues first, as was mentioned earlier. Once you fix those issues, then you fix the issue of domestic violence, because that is what prompted the issue of domestic violence. The fact that one, for example, one party may not be able to get sufficient access to the child, or one may not be maintaining the child sufficiently well. Those issues are the triggers for domestic violence application. So once the application comes before me and I open it up and I see these issues, I have to deal with everything. I'm not going to just address one thing and leave the other, and then send the matter and dispose the matter to say that, yes, you came for a protection order granted, case disposed of, matter finished. I can't operate like that. I've never been one to operate like that. And so I'm speaking from my own experience. Once the matter comes before me and I open it up, I'm going to address all that I see that needs to be addressed. When the parties come to me before the court, what I say to them is, what you're coming here and presenting to me as a judge is a wall. But what my role and function as a judge in this family court sitting is to create a bridge, especially if children are involved. Now, the bridge that I aim to create is not to get the adults back together per se in a relationship, but the bridge is for them to understand and learn better how to co-parent without violence. And so naturally, building a bridge when you've got a wall, tearing down that wall and building a bridge requires time. And the time involves counseling. I've heard my colleagues mention issues such as assisting the perpetrator. So for example, one of the things I used to do in my court, I used to send the fathers or the mothers, whoever come before me as a perpetrator, to go to heart, to get a skills training. And so naturally, those resources external to the courtroom will require some amount of time. So the case is not going to be wrapped up in the first or second hearing. It might be wrapped up within 6 months or 8 months because of what is required to fix the issues that came with this application. So while data and backlog is a concern and a focus in the Jamaican context, as a sitting parish court judge, I've always advocated that it cannot be applied in the same way with family court, because family court issues are different. And so they must be treated differently and given the time and resources that they need to build that bridge in order to create what is best for the parties involved.
So, Judge Maxwell-Whittingham, what I hear you saying is that data in and of itself, yes, it is useful, but you have to apply a human in the loop sort of approach where you're using the data to serve the needs of the people in front of you. And so the data cannot, especially with these matters, the data cannot be king, is what I hear you saying.
Yes, that's
What I am going to do is, I have some more questions, but I'm going to open up to the audience to see if there are any questions in the room. Are there any questions, any burning questions from anybody in the room? No questions? Nothing interest? You guys, yes, the lady in the back.
Hello, good afternoon. Alicia Davis, National Center for State Courts. Really enjoy the data-informed approach that you have, that you, both of you as have referred to in your presentations. And I wondered if there were a place that we could receive more information on the data elements or on the data model that you use.
So I think that question would be for Judge Maxwell-Whittingham, and I also think for Judge Dawson. So Maxwell-Whittingham, would you like to go first? You hear the
I'm
question?
sorry, could you just repeat? No, repeat the question for me, please.
The audience member would like to know, where would persons be able to find more information about the data integration model that is used by the Jamaican judiciary?
Okay, so there is an online platform that the Chief Justice has established. There is a page, a web page with the Jamaican judiciary. You should be able to get information, full information on that page.
And I'm sure we can provide you with the exact link at the end.
Right.
Judge Dawson?
I would say you should probably contact the Center for Center for Justice Innovation in New York State. They're the arm of the court that's our think tank that helps us create and implement these types of specialized courts. And if they don't, I'm sure they probably have the information, but if they don't, I'm sure they can tell you exactly where to get the data from.
Okay, we have, for one, yes. Judge Hines.
Hi, Sahai. Separate and apart from that, my question is for Judge Dawson. Forgive me, Sahai is my friend. Judge Dawson, I have so many questions. Like Sahai, I'm intrigued, and I'm probably going to sell it at home as well. My question is this. For the corresponding, as you call it, criminal matter, you mentioned it, different standards of proof, that type of thing, different remits, etc. Do you wait, per se? Is it intentional on your part? Do you, I mean, you deal with bail conditions and all of those things,
Yes.
but do you hold back on determination of the criminal matter while you allow the resource coordinator to work on the, in appropriate cases, of course, on the social aspects to try to achieve behavior modification? And then, if those are successful, do they have a corresponding positive effect, so to speak, on the outcome of the criminal matter? Maybe a guilty plea with mitigating factors because there's the successful behavior modification program, etc. I'm trying to appreciate how you merge by still separating the hats that you wear when you're in the criminal jurisdiction as opposed to when you are trying to deal with the injunctive relief and the behavior modification aspects.
Yes, thank you. That's a great question. So you're correct. I wear the different hats when the cases are before me. And we don't intentionally wait per se for the criminal case to be disposed of, because remember, these cases are still operating as though they were separate in separate courts, even though they're under one roof. But as it turns out, because we have cross-trained lawyers that could potentially be on both cases, that's not always the case, but most of the time, the lawyer who is representing the defendant on the criminal case is also representing that party on the family court case, because they understand the dynamics of that part. So they may, normally the prosecutor comes in with the highest plea offer, right, the first day, you know? And then as the case goes on, that plea offer may change because the prosecutor, and I encourage them, sit in the audience, hear what's being said on the family court case. You may get information that is helpful to you in terms of your prosecution. So invariably, the defense attorney will talk to the prosecutor about issues that are coming up on the family court case. Now, even though the cases are separate and distinct, just remember in New York, we have what's called an open courtroom. The courtrooms are not closed. So they're free to sit in, and when during the time certain they do, everybody's sitting there listening to the various cases that are being heard. So if I put a defendant in a program, or we call them respondents in the civil case, in a program on the family court case, for example, drug treatment, a battery intervention program, or I have them go into counseling, whatever the program may be, or if they're being monitored for substance abuse, they're being tested, and this was sort of, you know, the crux or the reason for some of the issues. We can use that information. That same lawyer who's representing the defendant on the criminal case and also the family court case may consent, because they would have to, because those reports are confidential on the family court case. They may consent to having this information given to the prosecutor. The prosecutor's reviewing this information and hearing what's going on. And so maybe now a plea that was initially a misdemeanor plea with jail now becomes a violation plea, which is not a crime, with a program, successful completion of the program, monitoring by the court. And when I say monitoring, they come back before me, even after they've taken the plea. Is this person compliant with the program? Are they abiding by the terms of the order protection? So I can monitor them however long the agreement is or whatever I want it to be. Usually it's up to a year. Sometimes it could be 2 years. So yes, the information and the review that's happening on the family court case can, quote unquote, mitigate. It's not really mitigating, but can mitigate the results that are happening on the criminal case. And often I'll say to the prosecutor, have you spoken to the victim? Because, you know, prosecutors, they don't need to listen to the victims, really. It's their case. They're the drivers of the case. But in this part, I think it's important for them to at least be responsive or understand the victim's consideration. Suppose this person is a primary breadwinner and there's an order of support. Maybe this is I have a matrimonial case. Not only they're paying child support, but also maintenance, spousal maintenance. Maybe they're covering all the carrying charges on the home. Do we want this individual in jail? How bad was the criminal violence? Maybe it is really bad and they should be in jail, right? But maybe not. So yes, the answer is yes. There is a certain level of mitigation, but not intentional, not on purpose, and that's not a criteria for resolving the criminal case with the outcome that you have.
Okay, so we don't have much time, so I'm going to give each of the panelists 30 seconds to leave the most important thing that you want the audience to remember. 30 seconds.
Yeah, thank you very much. I think in our country, it's very small, limited resources, and I'm impressed with what she has, a specialized court. But what we have been doing is that we've been doing much with what we have. And we have resource support services like the Family Services Unit, the Welfare Department, the Probation Department. We bring all together to make it work for us. And we have been striving to do our best. There's more that can be done, of course. And as we evolve, we will do more. But it will be driven by the needs as we see them, as they evolve. Thank you.
Yes, I would say if you're thinking about having a court such as the one that we have in New York, to start with baby steps. Rome wasn't built in a day, and I heard one of the speakers earlier say something similar, that sometimes it takes time. I think it's important to look to your specific jurisdiction, look at the resources that you have, look at the number of cases that might fall into a particular category. Up in New York State and upstate New York, we have some very rural jurisdictions where there's one judge that has to cover several counties, for example. So in those upstate regions, their IDV court maybe operates one day a week or twice a week. It's not a full court like mine operating 5 days a week. So there are modifications that could be made if you want to start a court such as an IDV court, just to see how it works, see what resources are in your community. In number two, I thought this was an excellent takeaway from one of the earlier speakers too. Having lawyers available for survivors of domestic violence is so important, and even respondents, quite frankly, because as a judge, and I'm sure my colleagues can attest to this, these litigants do not know the legal ins and outs. They don't know what motions to make. When you go on trial, it's horrendous. If they don't have a lawyer, they don't know what types of objections to make. They don't know, what's going on. So it's very, very challenging. They don't know what their rights are. So to the extent that you could, in your jurisdiction, have lawyers that are trained, but not only trained, but funded somehow. In New York, we're very fortunate. For people who are indigent, we have what's called 18B appointments, where we can appoint lawyers from the court to represent parties who are indigent. And there are a lot of civil legal service providers that also are available for litigants who are cannot afford counsel. In addition, we go to the bar associations. There's a criteria in New York where lawyers have to devote a certain amount of time to pro bono activities, so we reach out to bar associations. But we have a huge section of litigants who are what's called middle class. Frankly, if you make over $100,000 in New York City, you still probably, you need assistance. You can't hire a lawyer on your own, but that's a category of litigants that do not get the benefit of a free lawyer. So I think legal representation is huge. Training from the court officers on up and police officers, huge, because there is a culture out there that still needs to be trained. New people are coming on board every single day. They don't understand
30
these
seconds.
issues.
30 seconds, Judge
Oh,
Dawson.
sorry. Well, the last thing about that is also from the top down, it's important as a judge and as a leader to have that kind of attitude of respect and civility that passes down so that your staff knows when people walk through that door, you treat them with respect. No matter how they dress, no matter how they look. So anyway, I'll stop now. Sorry. I could go on.
Judge
but I won't.
Maxwell-Whittingham.
All right, so I'll just pick up where Judge Dawson left off on respect.
30 seconds.
Because, yes, respect. I find that in the family court, one of the things I have experienced is domestic violence matters are not treated with sufficient respect across the board. And it goes back to training and enforcement. So there are officers within the court system, police officers, they still treat domestic violence in Jamaica on a large scale as just man and woman business. And so a lot of times when the reports are made at the station, you find that the victim, so to speak, has to make a report at least 2-3 times for it to be taken seriously. And then after that, enforcement is a problem. Once the court issues a protection order and there's a breach, the victim is usually not assisted well enough in terms of enforcement. And so those are some of the things I'd love to see improve in the Jamaican context. What I'd like to leave with you is a little quote I made up for myself, and I use it everywhere. Justice without compassion is just as. And it's a play on justice. So if you break justice apart, you have JUST-ICES. So that's what I leave with you. Justice without compassion is just as. And I practice that daily because I do believe, even though I'm a judge, I'm not supposed to be a cold human being. I'm human being first. And so I always look to see how I can exercise compassion even to the perpetrator, to make that person live better than they came before me. Thank you.
Excellent. Thank you so much. And please, thanks to our panelists. And just as I will use my last 30 seconds to say that the three things that I'm taking away from this particular session are: one, the power of the protection order and the ability of the police and the magistrates to actually use that power. Second, data integration is great, but you have to integrate data by using a human in the loop approach. And thirdly, Jamaica, Trinidad, and Barbados will be adopting the specialized domestic violence court, of course. Thank you guys so much. Have a great day.
Thank you.
Oh, an incredible session indeed. Thank you so much. We're particularly blessed to have with us via Zoom Judge Sahai Maxwell-Whittingham in Jamaica. Please continue to stay safe. Prayers continue to go up for Jamaica. Thank you, Magistrate Douglas Frederick from Barbados and Judge Tandra L. Dawson from New York, and a particular thank you going out to Anika Gray, Director, Gender Equity Initiative, Northwestern University of Law, for excellent moderation of the panel. And yes, you will have your moment on stage, commemorate, capture. In the meantime, the rest of us in the room, what we want to do is, sure, continue to encourage you to use the Hoover app to ask the questions, and those questions will be answered online. But what we really want to do is encourage a lot of in-house engagement, all right, for our post-lunch panels. So I did use post-lunch specifically because that's exactly where we are heading now. So we want to thank all of our panelists so far, give them a huge round of applause for their insightful contributions and robust discussions so far. We're going to invite you to lunch. The lunch area is set up right outside of this room, and we will look to resume again, according to my watch, at approximately 2:20. Okay, approximately 2:20. Let's try to get our way back in. We just want to get some time because we know that you all have some amazing things to do later on this evening. So we want to give everything its full opportunity to happen. So when we resume, we will enjoy the next session and be fully integrated into integrated survivors protection through one-stop centers. So please, ladies and gentlemen, enjoy your meal. We'll be back in here at 2:20 p.m. sharp. Thank you.